Welcome to the Creditors Report.
Welcome to the Creditors Report with attorney Victoria A. Ferraro, managing member of Ferraro, Hancock and Associates, PLLC. Victoria is a Tennessee attorney with more than 20 years of experience representing creditors and financial institutions in bankruptcy, collections, repossession, and foreclosure matters across the state. I'm Chelsea, and today we're talking about how creditors can protect their rights during a bankruptcy case. Welcome, Victoria.
Hi, thank you so much.
Before we get into today's topic, can you share a little bit about your background and how you came to focus your practice on creditors' rights and bankruptcy work?
Oh, I'd love to. So I started law school in 1997, and it's just by fluke that I'm here and doing creditors' rights. I actually went to law school to do criminal, totally opposite end of the spectrum of where I am today. And when I graduated law school, I was kind of on the kind of confused about exactly how I wanted to take that area of practice, and so I decided to try something completely different. So my first job out of law school was working for a firm. I did bankruptcy and collection, and I've never left it. This is my 25th year.
When a borrower files bankruptcy in Tennessee,
Mhm.
what immediately changes for creditors in terms of what they can and can't do?
So when a borrower files a bankruptcy, actually in any state, an injunction goes into place, and that code section is 11 USC 362, and that injunction is called the automatic stay. And basically, that automatic stay pushes a pause button, especially depending on the chapter, on what a creditor can do. So at that point, up until the bankruptcy, a creditor was probably contacting the debtor, saying, "Hey, you've defaulted on this. You're not paying. Let's try to get this account back on track." They may have been, if it's a secured debt, they may have been looking for the collateral itself, trying to find it, to repossess it, to set off against it. Those things get paused, or they have to stop once that automatic stay goes into place. So all collection activity is going to stop. All the collection calls, all the letters, any emails that may have gone out. So when a borrower files bankruptcy, an injunction goes into place, and that injunction can be found under 11 USC 362, and it's called the automatic stay. And that basically is a pause button on any and all collection activities that had been occurring prior to the petition date, which is the date the debtor files bankruptcy.
Wow. What are the key notices or filings that creditors should pay attention to right away so that they don't miss something crucial early in the case?
So when a bankruptcy is filed, a bankruptcy notice is going to be sent out. And hopefully the debtor has listed all of their creditors so that everyone gets proper notice. And that bankruptcy notice is going to provide the petition date. It's going to provide what's called a meeting of creditors date. That meeting of creditors is where the debtor comes, and creditors are welcome to come. It's actually being recorded. It's under oath, and the debtor is asked tons of questions about their assets and about their liabilities, and about their ability to pay back. And the creditors can also ask questions. So that date is on there. A proof of claim bar deadline is going to be on there. So that bankruptcy notice is extremely important because it lets a creditor know different deadlines, objection to discharge, different deadlines that are going to be coming up during the course of that bankruptcy that they need to pay attention to in order to protect all of their rights. So the bankruptcy notice is crucial. Find it and follow it. Within the scope of that bankruptcy notice, as I said, there's going to be a proof of claim bar date. They need to get that proof of claim filed. So that's absolutely crucial. And depending on the chapter that was filed, they may want to go ahead and file a motion for relief or an objection to confirmation, something like that, depending on the chapter that was filed. So those are going to be the initial pleadings that the creditor wants to look at into filing, but it all stems from that bankruptcy notice. And that bankruptcy notice, they need to get it and calendar all the applicable deadlines that are in there.
We touched on this phrase, automatic stay. Many lenders hear the phrase automatic stay and assume it freezes everything. How should creditors think about the stay in practical terms and what they can do to protect collateral without crossing any lines.
So as we discussed a few minutes ago, it's freeze is a really strong word, but it actually is a pause button. So it's going to pause all of those collection activities that creditors were doing prior to the petition date. And now, since we're under the scope of the bankruptcy, we need to start looking about how can we maximize or achieve any type of benefit back from the bankruptcy itself. So are we going to file a motion for relief in order to seek possession of the collateral? Or are we going to file an objection to confirmation if it's a Chapter 13 plan where the debtor has proposed certain treatment for the creditor? Are we look at that Chapter 13 plan, see what the treatment is, see if you accept it. If you don't, let's get that objection filed. So those are the things that we can do within the course of the bankruptcy to start protecting our rights and try to see, about a return of payment.
How does the process differ between Chapter 7 and Chapter 13 when it comes to protecting secured interests?
So a Chapter 7 is typically a liquidation chapter. And that is where the debtors are looking to pretty much just a clean slate on all of their unsecured debt. If they have secured collateral, like a house or a car or something of that nature, sometimes furnishings, they're going to look at whether if they want to retain them or if they want to surrender them. If they want to retain them, then they're going to either redeem it or they're going to reaffirm it. And reaffirm is a document that they will do. It's called a reaffirmation agreement, where they are promising to pay back either pursuant to the terms of the contract, the original contract, or some type of modification that the creditor has agreed to. If they enter into that reaffirmation agreement, then the debt is not discharged. If they redeem the collateral, then they're actually going to pay a lump sum to the creditor within so many days. It's usually about 30 days. And then they will get the title to that piece of collateral. Beyond that, if they don't choose to reaffirm or to redeem, their debts are going to typically be discharged. And when I say typically, because there are times where a creditor may file an objection to discharge or something of that nature. But the typical Chapter 7 is very short in length. It's usually 6 months, 6 to 9 months. 9 months is on the long end. And the debtor's looking to discharge the majority of their debt. If they're going to keep anything, it's going to be under one of the scenarios that I said. And then they're looking for that clean slate, that fresh start. Chapter 13 is a little bit different. Chapter 13 is one of our reorganization chapters. So the debtor is going to file bankruptcy. They're going to file what's called a Chapter 13 plan. And in that plan, they're going to propose how to pay back their creditors. If they've got cars, if they have a house, they're going to put in that plan how they're proposing to pay those back. This plan typically lasts anywhere from 36 to 60 months. 60 is the max. And during the course of that time, once the plan is confirmed, then the debtors pay typically the Chapter 13 trustee, and the Chapter 13 trustee acts as the dispersing agent. There are times that the debtor can act as the dispersing agent on some direct pays, but typically the trustee is the dispersing agent. During that course of the 3 to 5 years, creditors' liens are still intact. And absent some other pleading that's been filed, they're intact until the earlier the payment of the non-bankruptcy debt or discharge. And the automatic stay remains in place, so no collection activities. If the debtor completes their plan and all goes well under a normal scenario of a Chapter 13, then they get their discharge. So it's a much longer process. And during the course of a Chapter 13, typically the debtor will pay back some percentage to their unsecured creditors versus just wiping them out completely. After they get their discharge is when any liens that are capable of being released will be released at that point. So
Okay.
it's different in that Chapter 7 liens will ride through. Also, and the debtors have to pick one of those ways of keeping their collateral. In a 13, they pay for it over a few years, and then they are able to get a lien release at the end in most situations.
Proofs of claim can make or break a case for a creditor. So, what details are most often overlooked when those claims get filed?
Oh, proof of claims. Um, you look at the proof of claim form, or most people do, and it looks like such a simple form to fill out. But at the end of the day, it actually does take quite a bit of time. Um, the creditor needs to make sure that the debt that they have on the face of that proof of claim is as of that petition date. And that's how much was owed as of the minute when the debtor filed, as of the day when the debtor filed. Um, they need to make sure that their itemizations are correct. So they have their principal balance, they have their interest owed, any late fees, anything of that nature. It all needs to be itemized out, and they need to have that total at the bottom, and that's what needs to be on the proof of claim. They need to make sure that all of their documentation is in order. They need to have the contracts, any perfection documents. A printed out itemization of the claim is extremely helpful and a lot of times required. And all of that needs to be put together in a proof of claim package to make sure that they are putting forth to the court the best possible picture of how much they are owed and why. That proof of claim is basically what's going to entitle them to payment. And so they need to have their best foot forward and show exactly what they're entitled to within the scope of that proof of claim.
In your experience, what's the best way for creditors to handle communication with a debtor's attorney or the trustee while staying compliant?
Well, I'm very fortunate in the state of Tennessee. Our debtors bar throughout the entire state is excellent, and they're all really, really good people. One thing that I always do, though, no matter the person, is I do everything in writing. It just makes for a cleaner record so that you can go back and you can reference it, and nobody is in the dark or in the shadows about exactly what was agreed to or what was discussed. If I do talk on the phone with somebody, I follow it up with an email, and I make sure that this was my understanding. And if there's anything different, then you please write me back and let me know. So my biggest recommendation when you are dealing with an opposing counsel or debtors counsel is, and to them also, to a creditors counsel, make sure everything is in writing so that you can actually go back to it and everybody's on the same page.
Great tip. Very important tip. If a creditor suspects bad faith or misrepresentation by the debtor, what
Mhm.
procedural tools exist to challenge that?
There are, um, well, let's start with the meeting of creditors. So the meeting of creditors we discussed earlier, on that bankruptcy notice, you're going to get told when that meeting of creditors is, and that's going to be your first time. I think creditors should look at a meeting of creditors as a free deposition, basically. Can't be as lengthy. I mean, you do need to be considerate of other people and not take all day. But you can utilize that time in order to ask the debtor questions where it's going to be on the record because it is recorded and it's under oath in order to try to figure out exactly, if you're thinking there is a misrepresentation or any type of fraud or anything of that nature, you can start asking those initial questions and trying to start drilling in a little bit about what's exactly happened and try to get the debtor on the record about what they did, what they didn't do, and things of that nature. So that first step is going to be that meeting of creditors. Again, free 2004, free deposition to really get in there and ask the debtor some questions. If you get past that point, or if you miss it, you can do a 2004 of the debtor. And so you're going to notice that up with the court and ask for 2004 to be put on the calendar, schedule that with the debtor. They're going to come in and that's going to be recorded and under oath also. And that's basically a deposition of the debtor where you can ask questions. If you already know it, like if you're already involved in a state court litigation and you've already been through that process and you know that there was an issue, you can file an adversary proceeding against the debtor for fraud or whatever the issue is. Fraudulent documents, false misrepresentation on a financial statement, whatever it is, you can file an adversary proceeding under 11 U.S.C. 523. There's different types that you can file, and go ahead and take that before the court. And it would be very similar to a state court litigation, but now it's going to be determined by a bankruptcy judge. So those are three really important things that you could do for that type of matter.
And finally, for creditors who are managing portfolios in multiple states, what's unique about Tennessee bankruptcy practices that they need to understand from day one?
Well, Tennessee has three different districts. Within our three different districts, and we have the Eastern District, the Middle District, and the Western District. Each one has their own local rules. So, and so just like anywhere, any state, you need to look at those local rules and make sure that you are following them to the best of your ability. Because even within the state itself, just take an objection to confirmation, for example, depending on which district you're in is when that has to be filed. So Eastern District can be filed the morning of the meeting of creditors, but not after the meeting of creditors. In the Middle District, it needs to be filed 7 days before. The Western District, you need to look at PACER and find that deadline for when it needs to be done. So what's unique about Tennessee would be the same anywhere. Look at the local rules to make sure that you're following them according to the individual district.
Awesome. Well, that's it for today's episode of the Creditors Report with Victoria A. Ferraro of Ferraro, Hancock and Associates. To learn more about how Victoria and her team protect creditors' rights across Tennessee, visit fhalegal.com. Thanks for listening, and be sure to like, subscribe, and leave a review if you found this episode helpful.
Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.